Hello, in this video, I'm going to discuss what is the Investment Advisors Act of 1940 and what does it mean to financial professionals today. My name is Michael Rasmussen. I'm an attorney in the state of Florida. I'm also a licensed solicitor in the United Kingdom. My law firm, United Atlantic Legal Services, works exclusively with investment advisors in the United States and in the United Kingdom as they work through the registration and acquisition due diligence processes. This is my YouTube channel, Last Week, This Week in RIA Compliance, where we discuss a lot of different legal and compliance topics related to investment advisors. If you find these topics of interest, please do hit subscribe. We look forward to having you join us on future videos as well. So again, we're going to talk today about what the Investment Advisors Act of 1940 is all about and what does it mean for financial professionals today. So the Investment Advisors Act of 1940 was the last in a series of acts that were created following the Depression of the 1930s and the stock market crash in 1929. Following this Great Depression, Congress had a report filed to them to try to explain the reasons why the Depression happened and why the stock market crashed in 1929. And out of that report, there was a number of reasons, a number of findings. Most of it had to do with issuers, the companies that are putting securities out into the universe for sale, having failed to adequately disclose or not disclose at all key risks associated with investing in that. But additionally, the report found that there were a lot of financial professionals at that time who were not acting in the best interest of their clients, rather that they were acting either consciously or unconsciously for the benefit of themselves rather than their clients. The report found that many financial professionals were not acting in the best interest of their clients, and rather, either consciously or unconsciously, they were putting their own interests ahead of that of their clients. So Congress enacted a series of acts, and that started with the Securities Act of 1933, the Securities and Exchange Act of 1934, and so on until we got to 1940, where they created the Investment Advisors Act of 1940. There's a number of other acts, including ERISA and the Investment Company Act of 1940 as well, that cover a wide range of different areas. But specifically here, we're talking about the Investment Advisors Act of 1940, which focuses in on those individuals that provide investment advice for compensation regarding securities. So in the Investment Advisors Act of 1940, you have the definition of who is considered an investment advisor, and we covered that in a previous video, so go check that out if you have questions about whether or not you may or may not be an investment advisor. It's a very important and fundamental question. But once you are considered an investment advisor, the Investment Advisors Act imposes a number of requirements on you. Some of those are negative requirements, meaning you're not allowed to act in a certain way, and other requirements are positive requirements, meaning that you are required to do certain things. The biggest takeaway from being an investment advisor when it comes to regulation and when it comes to the Investment Advisors Act and the subsequent court cases that followed in interpreting the Investment Advisors Act of 1940 is the idea of a fiduciary obligation. The Supreme Court found that under the Investment Advisors Act, there was the creation of what is called a fiduciary obligation between the investment advisor and their clients. What this means is that the investment advisor is to put the interests of the client ahead of themselves. There's really two different types of fiduciary obligations that the Securities and Exchange Commission and other regulators have found under that umbrella of fiduciary obligations. You have the duty of care, and then you have the duty of loyalty. Under the duty of care, we are talking about an investment advisor must act in the best interest of their clients, meaning that they have to provide advice that is suitable for the clients. They have to seek best execution on behalf of their clients, and they really have to monitor the client's assets to make sure the advice that they gave them originally is still appropriate for that client. Then you have the duty of loyalty. And the duty of loyalty is something of a catch-all, but essentially it says that an investment advisor is required to disclose material conflicts of interest that they may have between themselves and their clients. So, for example, if an investment advisor has multiple fee structures And one of those fee structures results in that investment advisor firm making more money off of a client rather than the other fee structure, that investment advisor really needs to take a hard look at whether or not it's more appropriate for that client to be in the lower fee structure, because the investment advisor has a conflict, and that conflict is that they make more money off of the fee structure number 2 rather than number 1. So there needs to be a constant analysis of whether or not the actions being taken by the investment advisor are in the best interest of the client. If there is a conflict of interest, that conflict needs to be fully and transparently disclosed to all of the clients of that investment advisor firm. So that's just one example of where a conflict of interest may arise. Another conflict of interest that arises quite often is where an investment advisor firm has an affiliated business, for example, a broker dealer, and they want to refer business over to that broker dealer. Again, there's a conflict of interest because that investment advisor would make money over on the broker dealer side of business. And they need to fully, transparently, and clearly explain to those clients that they're under no obligation to go over to the broker dealer and use those services. And that if they do go over there, the investment advisor is making money through the broker dealer on that side. There's what's called the ADV disclosure brochure, and this document really was created by regulators to ensure that those types of conflicts of interest were transparently and clearly disclosed to all of the clients. So the next thing I want to talk about is some of the other key provisions of the Investment Advisors Act of 1940, and really quickly kind of how they impact the investment advisors that fall under the purview of those rules. The first one is client agreements. Unlike many of you may consider client agreements to be a matter of contractual law, and it is. So your contracts are typically based off of the state in which they are executed, or there's a contract clause in your client agreements that say the state of Florida, for example, is the governing state for the purposes of that client agreement. But the Investment Advisors Act of 1940 also has some provisions that limit what can and cannot be put into those client agreements. And for example, should the client agreement, if an investment advisor wants to transfer a client agreement, there's limitations in the Investment Advisors Act as to whether or not and the manner in which those transfers can happen. So if you're a compliance professional and you're looking at your agreements with your clients, you're going to want to make sure you go to the Investment Advisors Act as well as your state laws and make sure that you're in compliance with both. The next thing that I want to talk about is the requirement to have a compliance program. So there's what's called Rule 2064-7, and that rule requires the investment advisor to have reasonably designed rules, policies, and procedures in place to prevent violations of the Investment Advisors Act and other applicable rules and regulations. Under that same rule, you're required to appoint a chief compliance officer, and that individual is responsible for the administration of that compliance program. So those are two kind of key provisions of the Investment Advisors Act when it comes to being an investment advisor and what the requirements are. There are many, many more. We don't have any time to jump into any more of those, but in another video, I'm sure we'll dive into some of these other key provisions. Again, my name is Michael Rasmussen. The law firm is United Atlantic Legal Services. If you wanted to learn more about what it means to be an investment advisor and how to stay in compliance, please do contact us. If you like this video, please do subscribe, and we will get more content your way shortly.